Hello and welcome. I'm Peter Afrasiabi. I'm an intellectual property litigator at the law firm of One LLP with offices in Orange County and Los Angeles. Today's program's coming from the trademark realm. Famous, or are you just almost famous? We're going to look at trademark and specifically dilution law to figure out what it means to be famous and when being almost famous just isn't quite enough. Now, one of the things before we get going is we have a lot of IP programs, done many of these programs for you, and these are for litigators, they're from transactional lawyers, and they're for IP lawyers to PI lawyers, and everyone in between. So you see on this slide we have here a series of different IP programs. For those of you particularly interested in IP, there's a lot of stuff to go look at. So if you just go do a search, you'll find it. I've done all these different programs. We've looked at trade dress in the space of shoes, and also cars, Ford versus Ferrari, but in the trade dress realm. A general IP overview survey for the generalist, looking at just the basics of trademark, copyright, patent, trade secret law. IP and due diligence for you transactional lawyers doing corporate transactions, thinking about the due diligence process. We have a whole program devoted to what you should be looking for when you're doing due diligence to make sure you cover all your bases on IP. We even let you learn all about copyright law, from the beginnings of copyright law, idea expression, all the way through to infringement and damages and fair use. The whole program built around exploring the music of U2 to learn copyright law. Programs on fair use, Hollywood TV, movies, ideas to look at, what is substantially similar? When does something get too close to something else? Another area of IP we've looked at is right of publicity programs, looking at dead celebrities, defamation through the Johnny Depp trials, voice control in terms of right of publicity over your voice and likeness, done a program on design patents, and of course, for those of you who love certain media, you can also explore copyright and trademark infringement principles through the world of Star Wars and Star Wars litigation that's happened over the years. And you can also explore the full history of all the James Bond litigation, which is another survey primarily and principally of fascinating intellectual property questions. Those are sort of the big pictures of where you can go. Today, of course, our overview, as you see here on this slide, we're looking at trademark law and famous questions. In other words, we're looking at super trademarks. These are marks that count as being famous under the law and get extra protection beyond just a regular trademark. In order to do this overview, we are going to look, first of all, at a quick review of trademarks and the federal protection regulatory regime that exists here. And this is going to allow us to look at a few cool cases. We're going to look at the big Jack Daniels case that went to the US Supreme Court in 2023. We're going to look at Porsche and their cars, and Louis Vuitton shoes we're going to look at. This will then lead us into dilution law, where we'll really start talking about famous brands and the legal claims they have, and what is fame? What does it take to be famous to have a dilution claim under the law? And this will allow us to look at some fun litigation battles that have been out there. We're going to look at Victoria's Secret as they took on Victor's little secret. We're going to look at Sony versus Sony Stream. And we're going to look at Spotify, who took on a marijuana company called Podify to figure out where they went in terms of were they famous enough to win. We're also going to look at almost famous questions. There's a Kim Kardashian supported selfie app, Pinterest company, the Theta Chi fraternity, and even Coach bags. And we're going to talk about what may be the ultimate test here, is the Jay Leno mother test. Personal brands we're also going to look at, and we're going to pivot towards the end to look at, since we're talking about brands and famousness and protecting them through trademark law, there's also the question of personal brands. And this is really where trademark law meets state right of publicity law. And this is going to let us look at Nancy Sinatra, Bette Midler, Vanna White, and some big significant personal brand cases that have been litigated where we have trademark meeting right of publicity. As we continue on though, you see here on our next slide, we're looking at trademarks. And so as we get going with a brief overview, we have to ask the question, what is a trademark? Well, it's defined by federal law. Trademarks are symbols, words, phrases, even colors that denote a product or a service's origin from one entity, and they distinguish it from others. Now, to be a trademark, it must in fact be used in commerce. In other words, if you have an incredible idea right now for an app, and you've got the best name in the world for this new app that you're going to go build and make and release one day, you don't have a trademark in it because you haven't used it in commerce yet. So trademarks have to be used in commerce to develop rights because they are source identifying by definition. They're not private secrets. Things that are generic, however, cannot be trademarks. But trademarks can be descriptive if you establish what is known as secondary meaning to show that that descriptive phrase or trademark has developed something unique in the perception of consumers in terms of being associated, therefore, with a brand as opposed to being just descriptive. On our next slide, you can see these photos here, and the question we're asking, what are trademarks? Do we have them? That's our title, as you see. And so what you should think about is the following: logos, taglines, company names, even the look and feel of a website can be what is a trademark. And so this requires you to also think beyond just words, but think about another area of trademark law, which is known as trade dress. Trade dress is trademark law, but it's in the realm of the design and appearance of a product or product packaging, which elements of, for example, product packaging make up the overall image that serves to identify the product presented to the consumer. And so this can include products, retail stores, or even websites. And so you see here a few photographs on our slide here. There's a very unique looking pill, medicine, that can have trade dress protection if that look and feel of that pill with the blue cap on top, the clear on the bottom, has developed source identification meaning to consumers, then that itself is a trademark, what we call trade dress, but it's a trademark. It functions as a trademark in commerce. On the far right of our slide, you can see a picture of the old Fuddruckers restaurant. And they established trade dress protection in the very unique look and feel of all the different distinctive elements that went into that restaurant. It's like TGIF's, for example, has trade dress in its very distinctive look and feel of its restaurant, because that distinctive look and feel of all the different innards of the restaurant itself functions as a trademark. It's source identifying. And even websites. You see a case there in the middle of a website that's been in litigation in terms of trade dress protection over the specific, for example, the types of photos, the organization, the layout. It can itself become source identifying and function as a trademark so that someone else cannot just come along and have very similar photos, very similar fonts, very similar color schemes, and just have a slight change to the name of the company and get away with it, right? So trademarks even exist in the website look and feel today. On our next slide, the question we're asking is, where does it find a home? Where does this come from? Well, it comes from the Federal Lanham Act. Here's the code, 15 U.S.C. section 1114. Any person who shall, without the consent of the registrant, use in commerce any reproduction, counterfeit, copy, or colorable imitation of a registered mark in connection with the sale, offering for sale, distribution, or advertising of any goods or services, or in connection with such use is likely to cause confusion or mistake or deception, shall be liable. And so the Lanham Act then defines the universe of things that can qualify as trademark, and this is from the U.S. Supreme Court, the Qualitex versus Jacobson case. But they've said it's in the broadest terms. Anything that human beings might use to carry meaning as a symbol or a device, hence a website look and feel, as we talked about. And so what the Lanham Act is intended to do is make actionable the deceptive and misleading use of marks and to protect persons engaged in commerce against unfair competition. That's the 2 Pesos versus the Taco Cabana case from the U.S. Supreme Court. One of the questions that people always ask, though, is, okay, I'm using a mark, I've got a brand, I've got a logo, do I have to register it? Well, here on our next slide, you can see the registration requirement question. No. You don't have to register to have a trademark, but to sue for federal trademark infringement, you do need to register. So the point is, it makes sense to register. Tell your clients, go register. If you're using a mark or brand that you perceive as having value, you may as well register it. It's relatively inexpensive to get trademark lawyers to do it. Now, if they haven't, you can still sue on an unregistered trademark. You would do it under the false designation of origin provisions, which substantively are very similar to trademark infringement in terms of what it's looking at. It's a different way of stopping people being confused by deceptive use of similar, phrases, marks, words, and commerce and whatnot. Now, the contra case, of course, is patent copyright law. Patent, you have to register to even have a patent. There's no such thing without government grant. And copyrights are distinct in the sense that, again, there's no registration requirement like trademarks, but there is an absolute requirement to register to sue anyone for infringement. So there's no sort of backdoor way to go into court to sue for copyright infringement against an infringer without registering, unlike trademark where you can still get in under the false designation of origin provisions. And in 2019, the Supreme Court in the Fourth Estate case did resolve a circuit split where the Supreme Court finally held that an application to register a copyright doesn't give standing. You actually have to have an issued copyright registration certificate. On our next slide, you see we're looking at the elements a plaintiff must show to claim a trademark. And to state a claim for trademark infringement, a plaintiff has to show that its trademark is, number one, inherently distinctive or has acquired a secondary meaning. Number two, defendant's use is likely to cause confusion among ordinary consumers as to the source, sponsorship, affiliation, or approval of the goods. And so you can think of it as two prongs. A valid trademark, I put it there in brackets for you, and that it's infringed through this confusion type standard. There's a presumption of validity for a registered mark, and if it's registered for more than 5 years, it becomes incontestable. That's 15 U.S.C. 1065. Now, what is the infringement test? On our next slide, you can see we're looking at infringement complexity, and this really brings us to the test. To assess trademark infringement is a multi-factor test. It's not one where you simply say, oh, the two things are similar, there ends the inquiry. No, it's actually a very complicated multi-factor test, and it looks at about 8, 9 different factors. It can look at even more. These are not an exclusive listing. These factors you see here on this slide come from the Ninth Circuit's 1979 decision, the Sleekcraft test it's known as. It's from the case AMF versus Sleekcraft. Every circuit's got a very, very similar test. There's additional factors that may get considered or used depending upon what kinds of products or services we're talking about. But the core of the test is the following. You balance the strength of the mark. How strong is it? Does that, cut in the plaintiff or the defendant's favor? The proximity of the goods between the two parties, the similarity of the marks being used. If there's any evidence of actual consumer confusion, the marketing channels that are being used, the types of goods which define the degree of care used to purchase, i.e. comparing a Ferrari to a Corvette versus, and do they look really similar such that someone would be confused into buying the wrong one, versus chewing gum that looks, Wrigley's versus a knockoff of Wrigley's, right? We use a lot more care buying a car. We're less likely to think we're buying a Ferrari when we're not, than perhaps chewing gum at the checkout stand, right? That's what that factor means. The defendant's intent is a factor, and the likelihood of expansion of product lines is also a factor. So that's sort of the test and how it works. We're going to look first at Porsche. And this is the case of Liquid Glass versus Porsche AG. It's reported at 8F sub 2nd 398. It's from the District of New Jersey in 1998. And basically you see there on the left an ad. And this is an ad by a company selling car polish. And you can see there it's got the model holding the cleaning rag, and it's, talks about anti-aging liquids. And it's got this beautiful red Porsche there, taking up, 80% of the real estate almost, or 60% of the real estate of the photo. Well, that ad came out in Motor Trends magazine in 1997, and Porsche wasn't happy because they're like, that's my car there, and it says Porsche, and we don't sponsor this liquid gel cleaning material, whatever it is, to clean cars. That's not what we do, and you're trading on our name to sell your car polish. So they sued. They were unhappy, and this is what the court held. The reason that Liquid Glass chose to use a Porsche instead of the vast array of other cars and chose to use and clearly display the trademark Porsche was not, in this court's opinion, because it needed a mere prop, but because Liquid Glass wanted to usurp Porsche's reputation and strength and persuade consumers that Liquid Glass produces high-quality products. Stated somewhat differently, Liquid Glass wanted to cash in on the goodwill that Porsche has worked hard to create and maintain by aligning itself with Porsche. And so that's an important example of trademark infringement because remember, liquid glass wasn't in the car business and Porsche is not in the car polish business. Totally different marketing channels, but they're trading on the goodwill and the name of Porsche to sell their product. Now, what if, for example, the case was, hypothetically put before a jury with a special verdict form, and the jury concluded that no one would ever think that Porsche is affiliated with this company. There was just no likelihood of confusion. But at the same time, the polish was of really poor quality, and maybe it damaged people's cars. And even though they didn't think there was an affiliation, maybe it's sort of somehow diluting the Porsche name, right? That gets us to what we're talking about a little bit when we talk about dilution. That's a teaser, because first, we're going to talk about shoes a little bit. And as you see on our next slide here, we've got Louboutin versus Yves Saint Laurent. And this is a Second Circuit case, 696 F 3rd 206, as we continue to walk through our trademark overview survey and we get closer to dilution as we flirt with it. The question here is, can the color red on the bottom of a shoe be a trademark? The answer is that a single color could be a trademark depending upon the facts and circumstances. So there's not a per se bar against a single color functioning as a trademark. The question then that confronted Yves Saint Laurent and Louboutin in this case is whether the color red as a sole has acquired secondary meaning for shoes. That is, the shoe on the left is the Louboutin shoe, which is that black shoe with a red sole. And the question is, when consumers see these high-heeled shoes with red soles, has that color red developed secondary meaning such that the association in the mind of the consumer is, oh, that's a Louboutin. It's a sort of nice high-end shoe, or it's the Louboutin brand, whatever. What the court held is that we see no reason why a single color mark in the specific context of the fashion industry couldn't acquire secondary meaning and therefore serve as a brand or source identifier, if it is used so consistently and prominently by a particular designer that it becomes a symbol, the primary significance of which is to identify the source of the product rather than the product itself. And on our next slide, let's see what happened. The court held that the huge ad expenditures on the sole as an identifier of the brand, the media coverage, the sales success evidence, the fact that they originated the lacquered red color there, consumer survey evidence, all upheld a finding that they indeed had a trademark on a red sole. But, this is a big but, the use of a red sole only applied as a trademark. It only functioned as a trademark when it was used in distinction to the uppers color. In other words, not on a red shoe, right? Because red is the distinguishing color to the rest of the shoe, and it's that red sole juxtaposed against other colors that makes red function as a trademark. So if Yves Saint Laurent has their red shoe with a red sole, that actually wouldn't infringe because the red sole there isn't functioning as a trademark the way it does when it stands in distinction to the other colors. We're going to go from shoes, though, to alcohol and to the Jack Daniel's case. And so you see on our next slide here a picture of Jack Daniel's, their famous liquor bottle, as you know. And then you can see a picture there of Bad Spaniels, and it's a chew toy. I mean, it looks like a bottle, but it's actually a chew toy for dogs. And this is a significant trademark case that went all the way up to the US Supreme Court in 2023. And basically, the facts are as follows. The Bad Spaniels chew toy had a kind of similar shape and other distinctive features that were similar to Jack Daniel's whiskey. Old No. 7 brand Tennessee Sour Mash whiskey is what's on the Jack Daniel's bottle, and on the toy they put Old No. 2 on your Tennessee carpet. Jack Daniel's bottle says its product's 40% alcohol. The Bad Spaniel's toy chew said it was 43% poo. The label and the bottle shape and design were similar, and those were trademarks or trade dress of Jack Daniel's. Now the defendant said, hold on, this is a parody. I mean, you don't make chew toys. We're not making alcohol. It's a total parody. It's First Amendment, freedom of speech. We get to do this. And the Ninth Circuit held that there was in fact no infringement because it was parodical in nature and it wasn't being used to designate a source, but it was really kind of free speech parody idea rights. Well, Jack Daniels, as you can imagine, was not happy with the Ninth Circuit's ruling. It went up to the US Supreme Court. And on the next slide here, you can see that the US Supreme Court unanimously reversed the Ninth Circuit. Not even one dissented to argue to support the Ninth on this one. What they held is that the defendant was using the marks, the shape of the bottle, the logo, the stylized kind of look and feel, the similar phraseology and all that. And even if it's a parody to designate their source of the product, it's not outside the bounds of trademark infringement. You don't have, in other words, the right to use a trademark as a trademark and claim that it's parodical in nature and therefore not escape infringement. And what they were doing was using this infringement as their own mark to sell the product in commerce. And so the use of a mark, this is the key quote, does not count as non-commercial just because it parodies or otherwise comments on another's product. Now, as to whether this was trademark infringement or dilution, perhaps, of this famous Jack Daniels brand, that got reversed and sent back for findings once the First Amendment stuff was taken off the table. And if you want to read the case, there's the site there from 2023 from the US Supreme Court. This now brings us into dilution law. On our next slide, you see here, we're going to start at the 1930s, where dilution was first discussed as an issue, where courts were dealing with the idea that, the protection of trademarks is the law's recognition, in essence, of the psychological function of symbols and how they work. And they're merchandising shortcuts to induce purchasers to select the things that he or she wants. And this is a quote coming from literally the 1940s, actually, from a case from the US Supreme Court, 316 US 203, the Woolen Manufacturing Co. case. And so you see there in the middle of the quote, "Whatever the means employed, the aim is the same, to convey through the mark in the minds of potential customers the desirability of the commodity upon which it appears. Once this is attained, the trademark owner has something of value. If another poaches upon the commercial magnetism of the symbol, the owner can obtain legal redress." And so what happens, though, is when courts started confronting issues where there wasn't technically infringement, but people were drawing on really well-known brands in a way that may not cause consumer confusion and be actionable, but it's still not fair to the brand, so to speak, because it's particularly well-known. And so states began adopting state-based laws, to prevent against this, what's known as dilution, this idea that the commercial magnetism is being taken. And despite, from the 1930s even up to the 1990s, lots of modifications to our trademark laws, no dilution law was actually ever formally adopted until we got to the 1990s. And that brings us, as you'll see on our next slide here, to the dilution statute, which is at 15 USC 1125 C1. The owner of a famous mark shall be entitled, subject to the principles of equity, to an injunction against another person's commercial use in commerce of a mark or trade name if such use begins after the marks become famous and causes dilution of the distinctive quality of the mark. What does dilution mean? You see in our second bullet point here, it means the lessening of the capacity of a famous mark to identify and distinguish goods or services, regardless of the presence or absence of competition between them or likelihood of confusion. In other words, even if there's no likelihood of confusion, there's no competition between the two people, totally different worlds apart. Dog toys, chew toys, alcohol, right? You really can't get probably more worlds apart than that. It doesn't matter still, even if the Spaniel toys were to prove no likelihood of confusion because no one would ever think there's a relationship. Jack Daniels, if it's a famous mark, could still say we have dilution protection, right? And so the example given, this is from the Mattel case in the Ninth Circuit, is, for example, Tylenol snowboards, Netscape sex shops, and Harry Potter dry cleaners would all weaken the commercial magnetism of these marks and diminish their ability to evoke their original association. These uses dilute the selling power of these trademarks by blurring their uniqueness and singularity and/or by tarnishing them with negative associations. And so this is where famousness, as added in the 1990s, becomes a very, very powerful area of trademark law for really famous brands, if they can be a trademark that happens to also be a famous trademark. What does it mean though? What is a dilution claim? Well, you can see on our next slide here, we're going to look at the dilution claim. To prevail on its dilution claims, a plaintiff must show the following. Number one, it has what is actually a famous mark. Number two, it's using a mark in commerce that allegedly dilutes the famous mark by blurring or tarnishment. So that's what the defendant's doing. And number three, the owner of the famous mark's use of that mark began before the opposer began after the opposer became famous. So, you know, if I start using a mark today, you infringe me tomorrow, but it takes me a year to become famous, I can't sue you for dilution because you used it before I became famous. So dilution by tarnishment and blurring means an association arising from the similarity between a mark or trade name and a famous mark that impairs the distinctiveness of the famous mark. So you can see there it's not tethered to would a consumer be confused. And so this is why it's really an important point, because if a famous mark is used on completely different classes of goods or to advertise different services, it gradually, ultimately will lose its effectiveness if it's being diluted out in different ways. And so if you imagine McDonald's as a famous mark, if it starts getting used for, you know, McDonald's car auto parts, McDonald's dry cleaners, McDonald's computers, McDonald's ABCD, it starts inevitably losing its effectiveness as being this unique source identifying mark for only that kind of fast food. Now, what this means though is not anyone who's got a trademark can have a dilution claim to protect. It's got to be famous fundamentally, and that is for marks that are basically household names. And so the important point though, of course, is that dilution can exist without even any likelihood of confusion. The question though always becomes, is it a household name, and what does it take to be a household name? And so this requires us, as you see on our next slide here, to assess fame compared to non-famous marks. And this line between the two is what we're going to now explore a little bit. So generally, a mark is famous if it's widely recognized by the general consuming public. And the factors courts look at to determine whether a mark possesses that necessary degree of wide consumer recognition include the duration of use, the extent of it, the geographic reach of the advertising and the publicity used on that mark, the amount, volume, and geographic extent of sales of goods or services offered under the mark, and the extent of actual recognition of the mark. Now in 2006, there were some limits. Congress revised the statute to specifically exclude dilution protection for marks whose fame only extends really to niche markets. So if you have a hyper famous, well-known brand of sedative marijuana used by people for medicinal purposes, and in that hyper niche market, everyone knows the name of your pot, that's not going to be famous for broad consumer protection across the nation because it's too niche. This brings us to our next slide of the battle between Victoria's Secret and Victor's Little Secret. So here's the background. Victor and Kathleen Mosley, they owned a retail store that they'd called Victor's Secret, and it sold lingerie, adult novelties, adult videos. Victoria's Secret, of course, complained, and they said, look, we're not happy. Victor's Secret, Victoria's Secret, you're trading on our name, our goodwill. So the Mosleys at first changed the name. They said, okay, we won't call it Victor's Secret, Victoria's Secret, Victor's Secret. We'll change it. It'll now be Victor's Little Secret. Victoria's Secret was still not happy, so they sued, claiming dilution. Now, they brought forth evidence that the defendant's conduct was likely to blur and erode the distinctiveness and tarnish the reputation of Victoria's Secret. They had affidavits from marketing experts that explained the value of the mark, but Victoria's Secret's experts didn't express any opinion concerning the impact of what Victor's Little Secret would do on the value of that brand. So they kind of put together a case, but was it enough? And so the case goes up to the Sixth Circuit, and this is what the Sixth Circuit held. Dilution was proved as a matter of law, even though there was actually no harm proved. That a defendant's mark dilutes the plaintiff's mark because of its tarnishing effect upon the Victoria's Secret mark. So in other words, what the Sixth Circuit held was that even though they didn't show up with any evidence that there was an explanation for how this would actually tarnish, dilute, damage, right? It just did it per se because Victoria's Secret's famous, Victor's Little Secret is damaging it, right? But let's see on our next slide what happened when this case went to the Supreme Court. So the case is now Victor's Secret versus Victor's Little Secret. It's in the U.S. Supreme Court, and it's undisputed that the mark was famous. So let's listen for a few minutes here to the oral argument, because it'll set the stage and frame the issues for us to understand what's going on with dilution. So listen to the next around 3 minutes of oral argument before the U.S. Supreme Court.
Well, how many consumers do you need? You say one isn't enough, and you say general consumer perception. I mean, if you had 20 people, would that be enough?
Well, the record and the briefs reveal some articles by trademark scholars who discuss...
Yeah, but I was asking you a particular question. Would 20 be enough?
I don't think so, Your Honor. We live in an age when consumer surveys, voter surveys, public opinion surveys are done over a weekend, and in this situation, that is the kind of survey that we would suggest.
And what do you ask these consumers? How many Kodaks are there? Is that what you want to ask them?
No, Your Honor.
What?
You ask them the scientifically designed question.
Which is,
do you think of another famous mark? And do you believe, as the Law Review article suggests, do you believe such things as whether or not the new entrant had to get permission from the famous mark in order to market this product?
Most consumers couldn't even understand that question.
And that's part of our point, Your Honor.
This sounds like a lawyer's dream. But it seems to me that the owner of the senior mark is entitled to more protection than that. I just want to make clear, you do not contest that tarnishment is a basis for the respondent to prevail in this case.
We do not.
All right.
As per se. What we say is that there is...
I don't know why you need sophisticated, so-called sophisticated polls to determine whether there's tarnishment.
Well, because, remember, this case is a statute that is wholly different than the common law. It has no common law antecedent. It is granting property rights through Congress's action under the alleged use of the Commerce Clause. And we say those property rights that are being granted by this statute create rights that go well beyond any trade area of a trade.
I would have thought, but you don't make a point of it, so I might be wrong. There's a pretty significant speech interest on your side of the case. That is, if this statute gets out of hand, advertising is part of whether we like it or not, our children's anyway, daily communication. And all of a sudden, if there's no real harm, you're going to cut off what people can say in commercial context. Now, you don't make much of a point of that, so don't let me put words in your mouth. Explain it to me.
All right, so you heard that. It was fascinating. It was a spirited argument you heard. And what the court ultimately held is that, as framed from that discourse that you just heard, and that was just a small snippet of it, to prevail on a dilution claim, you have to show actual dilution, not just a likelihood of it. So here's the quote. We do agree, however, with the court's conclusion that at least where the marks at issue are not identical, the mere fact that consumers mentally associate the junior user's mark with a famous mark is not sufficient to establish actionable dilution. As the facts of that case demonstrate, such mental association will not necessarily reduce the capacity of the famous mark to identify the goods of its owner, the statutory requirement of dilution. And here's the example the Supreme Court gave. For even though Utah drivers may be reminded of the circus when they see a license plate referring to the greatest show on earth, the greatest snow on earth, it by no means follows they will associate the greatest show on earth with skiing or snowboards. They may or they may not, but it's not necessarily the case. That's the key point. Blurring is not a necessary consequence of mental association, nor for that matter is tarnishing. And so this is the point. Just because a consumer may see a license plate that says greatest snow on earth and go, oh, that's cute, and associate it with the greatest show on earth, it doesn't necessarily mean that because there's a mental association, there's damage, there's blurring, there's tarnishment. You still have to prove that. And so this key point's really critical because it requires then a famous mark to really establish through proper evidence, generally expert evidence, that there actually is damage that comes from this association. There's blurring, there's tarnishment that follows from it, as opposed to simply a harmless association. We will shift, though, from Victor's Little Secret and Victoria's Secret to Sony now. And Sony took on a company called Sony Stream, or is it Sony Stream? And that's one of the questions. So we dealt here with a case where there was an applicant for a trademark registering SONI Stream, and this is for a streaming platform. And it was undisputed factually that it was an innocent use and it was not at all built to target off of Sony. In fact, it was put forward that no one was trying to capitalize on Sony, didn't even realize there was a connection, and it was pronounced Sony, not Sony Stream. It was pronounced Sony Stream. But nonetheless, Sony filed an action in the trademark office to stop it on both confusion but also dilution grounds, because Sony is a famous mark. For the dilution argument, this is what Sony argued. Sony is a famous brand, and SONI is not commonly pronounced as Sony. It's pronounced as Sony. That's what Sony said. The defendant said, no, SONI is pronounced as Sony, not Sony. But Sony brought forth experts, and these were linguistic experts, and their testimony was sufficient to establish that ultimately most speakers of Spanish in the United States are likely to pronounce the word SONI in the mark SONI Stream in the same manner as the opposer's mark. In other words, Sony Stream, not Sony Stream. And so the quote is that the record as a whole establishes that while Sony Stream is certainly not the only possible pronunciation of the Sony Stream mark, and may not even be the most likely one, it is at least among all the reasonable possibilities for its pronunciation, and we must consider it in our analysis of the similarity of the marks in the sound. On our next slide, you can see then what ultimately happened then is the trademark board used 6 different criteria to then figure out if the Sony Stream trademark would dilute Sony's brand. Does it tarnish the fame of Sony? And so the first factor is, well, what's the similarity between them? Well, that favored Sony because they said Sony Stream is regularly pronounced as Sony Stream, and so Sony Stream, Sony, very similar. That factor favors Sony. The degree of inherent or acquired distinctiveness of the famous mark, well, that favored Sony because it's a ubiquitous, well-known brand for many, many, many decades. The extent to which the owner of that famous mark is engaging in substantially exclusive use of its mark, and that favored Sony. Sony is the only Sony out there. It's not kind of a crowded field. The degree of recognition, there was lots of evidence that it favored Sony. It was a very, very well-recognized, broad consumer awareness of it, even for people not kind of out buying TVs and technology and Sony Walkmans and whatever. 2 factors did favor the Sony Stream defendant, though. Whether the use of the mark was intended to create an association, it was shown that it was neutral. It just wasn't done for that reason. They weren't looking at in any way to build off of Sony. And any actual association between the mark and the famous mark, and that was neutral too. There wasn't any actual evidence of a per se association between them. But let's see what happens. They lose, and that's the end of it then for Sony Stream. Had to change its name. So if there's a new streaming platform out there, it's not called Sony Stream anymore. Now these battles don't just show up in traditional tech companies and these areas, they show up in the modern lifestyle industries too. And this will bring us, as you see on our next slide here, to Spotify versus Podify. You see our 2 logos there. We've got Spotify's logo. You all probably know what Spotify is for streaming music. And then you've got Podify. And so what happened here is that the applicant, Podify, this is a case pending before the Trademark Appeals Board. They go in there to try to register a trademark, and they say, look, we want a trademark in the word Podify, and we want this for clothing, but also for software services related to medical marijuana dispensaries. Spotify was not amused, and they said, look, if you have some kind of software services for medical marijuana called Podify, that's just too close to Spotify. I mean, it's not just the IFY, and the green-white logo. It's also the word POTS in both of them. You just drop the S, and you're sort of, it's too similar, and it's software, and we're, streaming software too. The TTAB, that's the Trademark Trial Appeal Board, they found that Spotify, based on the record, was exceedingly famous, well-established, famous brand. And they found that Potify was strikingly similar to Spotify in appearance, sound, connotation, commercial impression. And the word plus design mark was dominated by Potify. Neither word has any particular meaning, so it's not being used for something else. And they're both used for software products that perform sort of similar functions. Finding music, one, like Spotify, we find our music. And Potify was so that you could find a medical marijuana dispensary. So the software was even conceptually similar in that sense. And so you won't be using the Potify software anytime soon because Potify lost. Can't register that trademark. Spotify was able to shut them down. This gets to some other questions, though, which is we've looked at famous marks now, and we've seen some examples of famous ones. But what happens when you're just almost famous? In this day and age, being almost famous, is it good enough? In trademark law, it turns out it's not for dilution anyway. And so the first case we're going to look at in the almost famous world, you see here on our next slide, is the case of ArcSoft versus Cyberlink. This case is reported at 153 F Sup 3rd 1057. It's coming out of the Northern District of California in 2015. And basically, ArcSoft made a selfie app, and it had 20 million downloads. To me, that's a big number. And it alleged that it had celebrities like Kim Kardashian, or all the Kardashians for that matter, using it. And ArcSoft described as perhaps the world's foremost authorities on the selfie. Probably true. The Kardashians are the world's foremost authorities on the selfie, and they said ArcSoft is it. They used the app. ArcSoft is how you do a selfie. So they said 20 million people downloaded it. We have been in the most famous, widely circulated publications in the U.S. talking about it. It's New York Times, Washington Post, Huffington Post, Daily Mail, blah, 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 right? Now, what ArcSoft didn't give, though, as the court found, was any authority for the proposition that 20 million downloads of an app is actually a material indicator of household name status, right? 20 million may be a big number, but does that mean you're just kind of known the way Sony's known? Well, court said the answer is no, you aren't. And so you simply showed a large number, 20 million, that's not enough. And so that didn't make this ArcSoft a household name. It just didn't work, right? That doesn't make you famous, 20 million alone. Not good enough, thrown out of court, at least on the basis of fame and famousness for dilution. So you could get Kim Kardashian touting your product to 20 million people. You could even be spoken about in the Daily Mail or in the New York Times. Doesn't mean you're famous. Household name is a very, very high standard. Now, another example of almost famous, if we want to shift on, involves Pinterest. And this is the case of Pinterest versus Pintrips. It's, again, coming out of the Northern District of California in 2015. You can see the Westlaw site there for you. And basically, this case started way back in the beginning when Pinterest first started. And so keep in mind, we're looking at a fact record from back in the day, not necessarily what is Pinterest today in 2023. We're talking about back in the beginning of Pinterest and this other company called Pintrips. So since 2010, Pinterest had this virtual pin board for people that can be organized by subject matter, and it had federal registrations. And for those of you who use Pinterest, you know how it works. It's kind of like a social media app thing that you can kind of pin stuff on and have feeds and the like. And that's probably the extent of how I can describe it since I don't use it. But nonetheless, Defendant was a travel website that people downloaded for software, and then they could, again, like Pinterest, have software pins for travel itineraries to them preserve costs and changes and itineraries and whatnot that they would pin. So this is a bench trial, and basically what happened is it was established Defendant Pintrips started operating in October 2011. Pinterest had been around for about a year at that point, 2010. So the first question is, in order for Pintrips to be liable for dilution, Pinterest had to be famous as of that date, October 2011. So the question then was just, had it become famous from 2010 to October 2011? And so here's what the record showed. Pinterest had approximately 1 million monthly users by the August of 2011. That's less than 0.5% of the US population. And according to Pinterest, demonstrative summarizing data included a report of less than 5 million monthly users by November 2011. That was just under 2% of the population. And what the district court said is neither figure comes close to suggesting that Pinterest has attained the level of prominence necessary for a brand to become part of the collective national consciousness. Even at 25 million users by 2012, the court held, it still wasn't famous. And you can see there it's cited to a Yelp case. This is Yelp versus Catrone. This is another Northern District case where there the court held, as it applied to the Yelp trademark, that the reach of publicity of the Yelp marks is extensive, as the site averaged 102 million monthly unique visitors between January and March 2013. And so what the court ultimately held is that given that level of ubiquitous, staggering, wide breadth use for Yelp to become famous, those numbers for Pinterest, even though they were kind of large, like that Kim Kardashian example we just gave you for that app, wasn't enough. And so the holding is that Pinterest simply didn't demonstrate the extraordinary high level of public awareness that a mark must reach in order to qualify as famous. So Pinterest, simply almost famous. Now in 2023, if someone came along and started a business called Pin XYZ, different story probably today, because I'm guessing today Pinterest, in the intervening decade plus years, would have data similar to that Yelp data, and it's probably become famous now. But on that record at that time, no, it wasn't. So the question this then, of course, gets to is, in these complex cases we've seen, as you see on our next slide here, how do you prove actual fame versus almost famous? Now, notwithstanding the oral argument in Victoria's Secret, you heard some of that stuff about, the judges at the Supreme Court, at least, justices at the Supreme Court, at least, talking about experts. Do we really need them? What's going on? How does this work? The truth is, expert survey evidence is fundamentally critical to litigation here. You can see it in McCarthy on trademarks and unfair competition, the section there citing it in terms of discussing this very high standard for fame, such as at least 75% consumer recognition in a survey. When you need numbers like that, you have to have expert surveys. It's the rarest of marks, really, where you can just go in and say, Judge, you know it when you see it, I'm famous. So for example, here, this Nissan case, 378 F3rd at 1014, the court found that there were simply disputed fact issues regarding whether fame existed, where the plaintiff had given evidence of 900 million in sales over 5 years and 65% consumer recognition. So nearly $1 billion in sales, 65% consumer recognition survey. Can't say you're famous as a matter of law. There's disputed fact issues here. We'll let the jury figure out if you're famous, right? That's a big set of numbers too. So it goes to show how high this bar is. This brings us to the fraternity case of Theta Chi fraternity versus Leland Stanford Junior University. It's our last bullet point on the slide here. And this basically involved a situation where this fraternity wasn't happening to use. It wanted to bring a blurring claim. And what the court noted is that, fame in just one line of business isn't enough to build up a dilution claim. And so the fact that the Theta Chi fraternity alleged that it had been one of the oldest fraternities in the United States. It was one of the most widely regarded college fraternities in the United States. It had over 175,000 members since 1856 in this sort of space of, fraternity spaces. That doesn't make it a household name. That's the point, right? It's too niche. You're not a household name. And so this is why in the beginning I said, we're going to look at the Jay Leno test. And so Jay Leno famously said, "You're not famous until my mother has heard of you." And that's a kind of a funny statement Jay Leno made about celebrity fame and the like. But you could actually kind of think of it, frankly, as being a pretty good articulation of our federal trademark dilution law. If your mother hasn't heard of the brand, it's probably not famous. In other words, everyone's mom needs to know this thing for it to be famous. That kind of encapsulates where we are on actual fame. Now, this, of course, brings us to another example of almost famousness, and we're going to look at, as you see on our next slide here, Coach bags. Are Coach bags famous? At first blush, you say, of course they are. Everyone's heard of Coach. Maybe, maybe not. And so this is the case of Coach versus Triumph Learning, LLC. It's reported at 668 F3rd 1356, and it went up to the Federal Circuit in 2012. And so basically, the fact pattern in this case was one where the defendant wanted to register the trademark Coach for educational services. Coach handbags, They opposed, saying, hold on, we have a mark, Coach, that we use on these famous high-end bags, and it's famous. And so therefore, any use by anyone else in any other area is going to dilute us and damage us. So it brought its claim, went to trial, lost in the trial court, and so it appeals up to the Federal Circuit. The Federal Circuit gets the case, and this is what the Federal Circuit did. Large sales over many years is not enough to establish fame because it's a very, very rigorous standard. So in other words, the fact that, yes, you've sold loads of these Coach handbags and you've made a ton of money, even though you may not sell that many bags since they cost so much, but nonetheless, even a lot of bags, they're not ubiquitous bags, but it's a lot of bags over many years, not enough necessarily because of the rigors of the standard. Myriad, they went on to hold, myriad federal trademark registrations and media attention. That also doesn't equate to fame. So just because you've also gone out and registered Coach and Coach logos and Coach trademarks and trade dress on the look and style of the bag, and even though you get lots of media attention about Coach and Coach bags, either maybe advertising that you've done, articles written about you, all that, that doesn't make you famous either. To prevail, you have to show that when the general public encounters the mark in almost any context, it associates the term, at least initially, with the mark's owner. That's at page 1373. So you see there, that is an unbelievably high standard. It means that basically, anytime the vast majority of the general public hears the word Coach, they just have to go, oh, handbags. If they don't do that, you're not making that right level of association to even get to the tarnishment question, right? And Coach itself, even though it's great for bags, it's a word that gets used in many, many contexts and has many, many uses in commerce too, such as a coach for educational services and the like. So that explains why Coach, at least on that fact record, wasn't famous. Now, if Coach were to bring another case, it could have a different set of evidence because when you look at a lot of the cases, they really hinge often on the specific facts that were adduced based on those surveys and at trial at that time. Things could be done differently in future cases against different defendants, conceivably, maybe, maybe not, but Coach, almost famous. On our next slide, I pose the question for you, how do you avoid being just almost famous? No one wants almost fame. Everyone wants fame. Well, a long length of use, a very large publicity marketing sort of world that's existed around that very, very long use, including what's very, very important here is a huge amount of unsolicited press, because unsolicited press is part of the mechanism by which experts can show that the brand has become famous. It's just part of the consumption of society, the dialogue of society that exists. Widespread geographical ads are important. Staggeringly large sales volumes are important. And so here, what you see is that you must have an extensiveness of consumer knowledge of the mark well outside normal buyers of the product. And so the great example here is this case that I got for you from the Eastern District of Pennsylvania in 2001, the Crayola case. And here's what Crayola was able to show. 92% of the primary purchasers of its products recognized the trademark Crayola. It had virtually universal recognition. So in other words, and you can imagine that's actually probably very true. You could survey almost anyone and they hear the word Crayola, they're like, yep, crayons. It meets the Jay Leno test for sure. So the point that's really important here though is that survey evidence fundamentally is beyond critical. It's beyond critical for a plaintiff and for a defendant to defend these cases. And so if you're involved in a fame case, get an expert and get them early. Because if you don't have the right expert, even the absence of an expert in the record will lead to judges noting the absence of the expert and that having some significance to the analysis. And you see here the quote, consumer surveys could be used as evidence of such fame, but consumer surveys are absent from this case. That's in a case coming from the First Circuit, the IP Lund case, and then you see the Bluetooth case at 463 F Sup at 1190, where the court actually noted the absence of a survey to demonstrate actual brand recognition. So they're not losing because they don't have it, but they're saying, yeah, you don't have it, that's telling me something, you're probably not famous. You know, if you double click on that, what it's really showing is that the absence of expert survey evidence, what it really telegraphs to a court is, you went out and surveyed it, you didn't establish what would be needed to show fame, so you're just going to sit on the surveys as, you know, work product and not produce them in litigation which means you know you're not famous. Right? And you're now trying to do a Hail Mary. Now let's take a quick jaunt through trademark law colliding with right of publicity law. You see on our next slide here, personal famous brands. And so we've talked, this whole program has been built around trademark dilution law, what's famous, what's almost famous for purposes of dilution within the realm of trademark, the dilution of brands. But we also have personal brands. We mentioned Kim Kardashian, the name Kim Kardashian, that's her brand, right? And it's her right of publicity in her name. And so this gets us to state right of publicity issues, and we're going to look very briefly here as a little sidebar at some state right of publicity claims as we look at how personal brands get protected. These are done through primarily state law. The root right is the right of publicity, and it's the right of every person to control the commercial use of his or her identity. These rights can last from 10 to 100 years, even after death. So for that reason, the estate of James Dean is still able to sell and license his name and likeness and image to make money. Now, there are different state rules all across the country. Some allow it, some have retroactive, some don't. Some allow it for deceased people, some don't. Some require that if you're deceased, for the heirs to benefit by it, the deceased had to be famous at the date of death. There's a whole variance of remedies and substantive tests that exist. Some states don't even have the right. And so if you look at some of the other IP programs I've done one on dead celebrities, we've really gone deep into the question of do we even need, and don't we at this point need, a national right of publicity to federalize this so that we have consistency across the country. But in any event, that's a quick overview. Let's take a quick look at a few cases as we go through this. And the first case we're going to look at is the case of White versus Samsung. And you see there a picture of robot Vanna White turning the Wheel of Fortune letters. And so basically it's a Samsung ad. Samsung had a robot in a wig and jewelry next to this kind of Wheel of Fortune brand, and it was presented to kind of resemble Vanna White, next to the game board, and it kind of recognizable as her, and they're advertising their Samsung, televisions or whatever. White wasn't happy. She sued under California right of publicity law, and the court held that television and other media create marketable celebrity identity value, and so energy and ingenuity are expended by those who've achieved celebrity, and so you don't get to exploit it for profit. And here, the law protects the celebrity's sole right to exploit this value, whether the celebrity has achieved her fame out of rare ability, dumb luck, or a combination thereof. And so that basically showed that when you want to take someone's personal brand, their look and feel, and use it in a commercial, you can't do it. So they lost at summary judgment. They owed Vanna White money. Now, there's a way to look at this through the federal prism, too, and this is on our next slide, Nancy Sinatra versus Goodyear Tire. And you see there, Nancy Sinatra, these boots are made for walking from her video, and you can watch this little clip for a minute here first to understand kind of the whole Nancy Sinatra look and feel. Let's check out the clip.
What are the hot cars wearing this year? Boots. Why boots? GT tires from Goodyear.
These boots are made for rolling wherever cars are hot. White boots GT from Goodyear. What sports cars need, they've got.
Check the specs. Built low and wide like racing tires. Low cord angle. 4 plies polyester cord. Track tested at 130.
These boots are made for rolling wherever cars are hot. White boots GT from Goodyear. What sports cars need, they've got.
If you drive a high-performance car, you need Goodyear's finest high-performance tire.
All right, so what you can see here is that Goodyear was using her song in a commercial, and she said, hey, you're passing this all off as being me, that the song, the arrangement, the girls, the dancing, the way we all look, it's associated with me. It's my brand. Doing all of that is me, my brand. You're taking it. Not fair. Went up to the Ninth Circuit, as you see in our case site there, and the Ninth Circuit said, Sinatra and Goodyear are not in competition in any manner. I mean, Goodyear's not passing off its tires as her products, or her records as its products. And the Ninth Circuit then said, no, you don't get to bring a federal kind of right of publicity type claim under the Federal Lanham Act or under this is before some of the state statutory laws we have. You don't get to bring these claims and control the ability of others to make music or musical performances as being kind of evocative of you. And so really what happened is Sinatra at the end of the day was trying to, they said, by using state unfair competition laws, fundamentally encroach too much into the realm of federal law and copyright and somehow monopolize performances and music in a way that just was not okay. Now that was in 1970, but if you fast forward a little bit, you can see here the case of Midler versus Ford, and this brings us to 1988, and if you watch this 30-second commercial real quick, you'll see or hear what Ford was doing.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man, oh baby.
Mercury is bringing a sophisticated new shape to the American road. Introducing Sable. Mercury, the shape you want to be in.
All right, so you heard that campaign. This was a Ford ad campaign to sell their cars, and they wanted to sort of have someone that sounded like Bette Midler singing a Bette Midler song. They asked Bette Midler, she didn't want to do it because she didn't want to, hawk, her name to, sell cars. Just didn't want to do it. So they went and found a sound-alike. And the sound-alike sang her song. They had the rights to use the song from the copyright owners. They licensed the song properly, but they hired a sound-alike to sound just like her. And so Bette Midler was not amused, and she sued and said, no, my voice is my personal brand. And you don't get to falsely create the idea that I am supporting your car by having a sound-alike sing a song, even though you had the rights to sing the song. Because it's a sound-alike, it's making people think I'm sponsoring the car. And the Ninth Circuit agreed and found that this was a right of publicity violation and that the Ford Motor Company was unable to do this without violating her rights. And so that's an example of where the personal brand, down to the voice, her famous distinctive voice and vocal style, is protected. Well, you can see now we're on our conclusions as we come to the end of this program about brands and tarnishment. And you see here we have the perfect photo for you. There's endless numbers of brands that have been blurred out in the photo for us to think about the myriad brands we encounter every day. How many of them are indeed famous? Brands, of course, are protected through trademark law, we know, but we also have spent a lot of time clicking and double-clicking again on dilution. And it's a very powerful claim for famous brands because it's divorced from proving actual confusion. Now, expert surveys, absolutely critical. You've got to construct them well, and they're critical to establish fame. And again, remember, don't confuse popular with fame. Don't even confuse tens of millions of downloads or uses with fame. Fame is ubiquitous such that everyone knows it, basically. It's just part of the common collective dialogue of society. And finally, we looked at personal brands and the state right of publicity and how it protects one's personal famous nature, such as Bette Midler's voice, from being used without her consent. Thank you, and as ever, if you have questions, please email me.